Welcome to another edition of AmericanFreePress.net. I'm Mark Anderson, corresponding editor for American Free Press, and I'm here at the Health and Freedom Conference in March 2009 in Irvine, California, the annual one put on by Payman's Freedom Law School. And I'm with Tommy Cryer, a well-known attorney from Louisiana, noted for beating the IRS himself when he was accused of not filing taxes and under the alleged legal framework that the IRS tax code actually obligates us to pay taxes under the federal income tax structure. At any rate, that aside, Tommy then went on to represent February 24th a Charles Bim. And Charles Bim, notably, was found to not be liable, that is, he did not break the law in not filing income taxes since 1999 and every year since then up until the present. And Tommy, if you would, tell me a little bit, you're representing Charles Bim in a Jacksonville courtroom. As I understand it, the Bar Association down there, based on some past events, said that Charles Bim, an attorney himself, did not file income taxes and said that was a criminal act, but in fact the judge ruled just the opposite. So how did that go? You're in there representing it. How did this turn out?
Well, we tried the case in a very short duration. It was in less than one full day. And of course the bar had put up an expert in the form of a CPA who testified as to what the IRS standard was on cross-examination, though he was unable to justify or to establish or to point out any particular law that made Mr. Bim liable in the first place. He was also unable to cite or indicate that he had referred to any of the Supreme Court authorities on what was and was not income, nor did he understand or have any knowledge of what was or was not taxable or exempt from taxation. And Mr. Bim then testified as to his acquisition of information. It indicated that the Internal Revenue Service's version of the law is not supported by the law itself, and that he did not file because the law didn't impose a legal obligation upon him to do so. Judge Tyree Boyer, who heard the case, ruled that Mr. Bim had not violated any criminal law, that he had not committed a criminal act, and found that he was not guilty of any crime in his refusal to file federal tax returns since 1999. This is significant because, number one, it is a ruling from a judge, not a jury, so it cannot be said to have been a case of jury nullification. In this particular instance, the judge acknowledged that this man was innocent of any crime. There was no question, it wasn't an issue that he had refused to file tax returns. It was just simply a question of whether refusing to file tax returns is a crime in his case, and the judge says it was not.
So it really sets sort of a new standard in a way that a judge ruled that it's not a crime for him not to have filed income taxes, and we're talking an almost 10-year period. In your case, where you got a ruling in your favor in 2007, you were accused of not filing for 2 years.
Right.
This guy covers almost 10 years. The judge says that's not a crime in him not filing taxes in that period of time. So this is probably something that won't see much, if any, media coverage from the Jacksonville, Florida press, or certainly not from the national press. But this really sets quite a new turning point in this, doesn't this whole development?
Absolutely, because it's a judge that is reviewing, not just a jury that could be swayed by this factor or that factor. We're talking about a very seasoned judge, Judge Tyree Boyer, who's been a judge for a very long time in Florida, and is a very bright and very intelligent man. I mean, I can tell through the process that he understood the law. And this wasn't a mistake, it wasn't an error on his part. He was able to see that the law, that the bar was unable to prove that Mr. Bim believed or was aware of any lawful obligation on his part to file a tax return. Consequently, he was able to determine that Mr. Bim's belief that he was not required to file, and the fact that Mr. Bim could give good sound reasons why the law said something different from what the IRS says, what he was really legally impossible for him to have found otherwise. And the fact that juries find people guilty is simply because they don't really understand. But that judge did understand, and he made a ruling that was exactly correct.
He wasn't just making some unwitting assumption here. He obviously understood. What I find interesting is if anybody could nail somebody on tax evasion, it would be the Bar Association going after one of their own for violating the bar standards or rules or bylaws, and even they couldn't make it stick.
That's right. I mean, here the entire Bar Association, all the attorneys collectively, in effect, and represented by a hand-picked council, hand-picked by the Supreme Court of the state of Florida. Mm-hmm. And so, I mean, if there was any guilt there, you can know that they would have been able to have squeezed it out and put it on the table, but they couldn't do it.
Now, moving this along, I understand from our earlier conversations that this automatically may kind of be notched up to the Florida Supreme Court level. So it will be heard again, or does that remain to be seen? How does that work?
The hearing was conducted before the judge who served as a referee on this particular case, and he made his findings, and then he makes recommendations as to what the disposition should be. It is always the last word of the Supreme Court, but the Supreme Court, not having heard this matter, will give a great deal of deference to this judge's findings.
I see. So it looks like Charles Bim may have even unintentionally set sort of a new precedent. Could this possibly be comparable to the John Peter Zenger case in Freedom of the Press, the old colonial case where that publisher was found not to be telling libels because truth, if told truthfully, is not libel? It cannot be a libel if it's true?
Well, in this particular case, it's belief as a defense instead of truth as a defense. But the fact is that his testimony made it very clear that not only did he believe it, but that it was true. The evidence was overwhelming in establishing that the law did not impose any duty upon him, that it did not make him liable, that it did not require him to keep returns, that it did not require him to make statements or even give information to the Internal Revenue. And it didn't even make him responsible for keeping records.
Last question. In terms of us kind of showcasing in that hearing, kind of a short day hearing, you're saying that the law really doesn't require someone to file an income tax. Was that based more on your getting that out of Charles Bim sort of through questioning, or did Charles Bim know on his own and explain on his own to the judge, showing the judge, you know, or kind of putting that argument into a forceful manner? You know, did he prove his own case, or did it take you to kind of get it out of him? I guess is what I'm after.
It requires both, because testimony has to be taken in a question-answer format rather than a narrative format.
Right.
As a matter of fact, the judge, repeatedly stopped him to tell him, I don't want you to argue the case or answer questions. So an answer-question format is necessary. But the overview of the matter is that the CPA that they had tendered as an expert didn't know anything about what was or wasn't income. He could not show us any liability provision applicable to Mr. Bim, and he didn't know how to tell whether something was exempt or taxable. And then on the other hand, Mr. Bim was able to demonstrate with very clear authorities, and he did it very forcefully, and he did it very clearly, very articulate, did a good job of explaining to the judge why his beliefs changed from the rule of law that he had been following based upon what he had heard to the rule of law that he followed based upon what he had read.
Did Mr. Bim, from starting in 1999, I assume you didn't know him back then, and that this man simply on his own volition decided not to file? In other words, not through any outside influences of whom you're familiar, that you just, I assume you haven't known this guy that long, and that he did this on his own accord.
No, I only met Mr. Bim after the disciplinary action had been initiated against him. He had learned this on his own and through tutelage of another attorney who was knowledgeable of these issues.
Interesting.
And he had done his own research, and he concluded the same as I had, that as an attorney sworn to uphold the Constitution and the law, that he had to take a stand, that he had to refuse to file tax returns and call it to the attention of the courts and the IRS that he wasn't going to follow their dictates. He was going to follow the law as he was required and sworn to do.
Moving this along, was there any media attention to this at all, or was it more of a private sort of thing?
All bar complaints, or bar disciplinary actions are confidential, and so therefore,
That question answers itself.
publicity is prohibited. I have obtained Mr. Bim's consent to speak publicly with you about this.
Would he talk to American Free Press, namely me, soon? Could I call him? Would he be open to that, or we could just limit it to this interview?
No, he would be happy to talk to you.
Okay,
He would
very
have an
good.
interview.
Well, thanks, Tommy Cryer. Great to see you again here from the Health and Freedom Conference 09 in Irvine, California. I'm Mark Anderson with AmericanFreePress.net. Call us at 888-699-NEWS for subscription and other information, and check out our newspaper. We'll see you next time.